Imagine waking up tomorrow morning to see military troops patrolling the streets of your city, not because of a natural disaster, not because of a foreign invasion, but because the President of the United States decided to send them there over the explicit objections of your state's governor. Now imagine that when federal judges say this is unconstitutional and order those troops to leave, members of Congress respond by trying to impeach those judges. And finally, imagine that elected officials from both major political parties are now openly using the phrase civil war to describe what's happening in America right now, not as a metaphor, not as hyperbole, but as a genuine warning about where the country is headed. If this sounds like something from a political thriller or a dystopian novel, I need you to understand something crucial. This is not fiction, this is not exaggeration, and this is not happening in some distant future. This is happening right now, in January 2026, in the United States of America. President Donald Trump has deployed National Guard troops from Republican-controlled states to Democratic cities across the nation. Federal judges appointed by presidents from both parties have ruled that these deployments violate the Constitution. In response, Republican lawmakers have filed articles of impeachment against at least one of those judges. Democratic governors are calling this an act of war against their states. Legal scholars are warning that we're witnessing the most serious constitutional crisis since the Civil War itself. And all of this is unfolding while ordinary Americans go about their daily lives, many completely unaware of just how unprecedented and dangerous this moment truly is. In the next 15 minutes, I'm going to break down exactly what's happening, how we got here, what the law actually says, why multiple federal judges, including Trump's own appointees, have ruled against him, what this means for the future of American democracy, and most importantly, what you need to know and do about it. This is not a partisan issue. This is about the fundamental structure of American government and whether the system of checks and balances that has existed for over 2 centuries can survive. So whether you're a Democrat, a Republican, an independent, or someone who doesn't usually follow politics at all, I need you to stay with me for the next 15 minutes, because what's happening right now will affect every single person in this country for years and possibly generations to come. Let's dive in. Welcome back to the channel. And if you're new here, you've chosen quite a moment to join us. What we're going to discuss today is complex. It involves constitutional law, federalism, separation of powers, and the delicate balance between state and federal authority that forms the foundation of the American system of government. But I promise you, I'm going to explain all of this in clear, understandable terms without requiring you to have a law degree or a political science background. Here's what you need to know right from the start. Over the past several months, beginning in mid-2025 and escalating dramatically through the end of that year and into this new year of 2026, the United States has been experiencing what legal experts, political scientists, and even some military analysts are calling an unprecedented constitutional crisis. At the center of this crisis is President Donald Trump's decision to federalize National Guard units, which means taking control of them away from state governors and placing them under federal command, and then deploying those troops to major cities in states controlled by Democratic governors. These cities include Los Angeles, California, Portland, Oregon, Chicago, Illinois, and Washington, D.C., among others. The stated purpose of these deployments, according to the Trump administration, is to assist with immigration enforcement operations, to support federal law enforcement agencies like Immigration and Customs Enforcement, and to maintain public safety during what the administration characterizes as violent protests and civil unrest. However, the governors of these states and cities, along with legal experts and civil liberties organizations, have challenged this characterization. They argue that the real purpose of these deployments is political: to intimidate Democratic voters ahead of the 2026 midterm elections, to assert federal dominance over blue states that have been critical of Trump's policies, and to normalize the presence of military forces in American cities in ways that fundamentally alter the relationship between citizens and government. These challenges have led to a series of legal battles in federal courts across the country. And here's where things get really interesting and really concerning. Federal judges in multiple jurisdictions, including judges appointed by President Trump himself, have issued rulings blocking these deployments or ordering troops to return to state control. These judges have found that the administration's legal justifications for federalizing the Guard don't hold up under scrutiny, that the deployments violate constitutional principles of federalism and state sovereignty, and that allowing them to continue would create dangerous precedents that could be abused by future presidents of any party. The administration's response to these unfavorable court rulings has been to largely ignore them while appealing to higher courts. And in at least one case, Republican members of Congress have filed articles of impeachment against a federal judge who ruled against the president. Meanwhile, the rhetoric from politicians on both sides has reached fever pitch, with multiple Democratic governors and members of Congress warning that Trump is pushing the country toward civil war, while Republican supporters of the president accuse Democrats of undermining law enforcement and enabling chaos in their cities. To understand why this is so serious, why it matters so much, and what might happen next, we need to examine the timeline of events in detail, explore the legal framework that governs National Guard deployments, look at what the courts have actually said in their rulings, and analyze the broader implications for American democracy. That's exactly what we're going to do in the next several minutes. So let's start with the essential context you need to understand everything else. To truly grasp why the current situation is so extraordinary and so troubling to constitutional scholars, we need to understand both the legal framework that governs military deployments within the United States and the historical precedents that have shaped how presidents use this power. The National Guard occupies a unique position in American governance, and this dual nature is at the heart of the current controversy. Unlike the active-duty military forces like the Army, Navy, Air Force, and Marines, which are purely federal entities under the direct command of the President as Commander-in-Chief, the National Guard exists in what's called a dual status. Under normal peacetime circumstances, National Guard members are under state control. They're organized into state units, they're funded partially by state budgets, and most importantly, they operate under the command of their state's governor, who serves as their commander-in-chief for state missions. This is why you see National Guard troops responding to hurricanes in Florida, wildfires in California, or civil unrest in any state. They're operating under state authority at the direction of the governor. However, the National Guard can also be federalized, meaning the president can take control of Guard units and place them under federal command. This is governed by several provisions of federal law, primarily found in Title 10 and Title 32 of the United States Code. Title 10 allows the president to call National Guard units into federal service, at which point they essentially become part of the active duty military under federal control. Title 32 allows for a hybrid status, where Guard members can perform federal missions while technically remaining under state authority, which is often used for things like supporting federal disaster relief efforts. The critical question that's at the center of all the current legal battles is this: under what circumstances can the president federalize the National Guard against the wishes of a state's governor? The law provides several scenarios. First, the president can federalize the Guard when the United States is invaded or in danger of invasion, which obviously doesn't apply to the current situation. Second, the president can federalize the Guard when there's a rebellion against the authority of the United States government, a provision that dates back to the Insurrection Act of 1807 and has been amended several times since. Third, the president can federalize the Guard when domestic violence or unlawful combinations make it impracticable to enforce federal law through ordinary judicial proceedings. This third category is where the Trump administration has been hanging its legal arguments, claiming that protests and resistance to immigration enforcement operations constitute situations where federal law cannot be enforced through normal means. Now let's look at the historical precedents, because this matters enormously. Presidents have federalized National Guard units many times throughout American history, but the context and circumstances of those federalizations are crucial to understanding why what's happening now is so different. The most famous and most relevant precedents come from the civil rights era of the 1950s and 1960s. In 1957, President Dwight Eisenhower federalized the Arkansas National Guard and deployed the 101st Airborne Division to Little Rock to enforce federal court orders requiring the desegregation of Central High School. Governor Orville Faubus had actually used the state's National Guard to prevent black students from entering the school in defiance of federal law and court orders. Eisenhower's federalization removed those troops from Faubus's control and ensured they would support rather than obstruct the enforcement of constitutional rights. Similarly, in 1962 and 1963, President John F. Kennedy federalized National Guard units in Mississippi and Alabama to enforce desegregation at universities when state authorities were actively resisting federal court orders. These precedents are important, but here's the crucial difference between those situations and what's happening now. In every one of those cases, there were clear federal court orders being violated by state authorities. There was explicit state defiance of those federal orders, and the federalization was specifically aimed at enforcing the Constitution and protecting constitutional rights, particularly the Equal Protection Clause of the 14th Amendment. The current situation is essentially the inverse of that. President Trump is federalizing Guard units and deploying them to cities where there are no federal court orders being defied by state authorities, where governors are not obstructing federal law, and where in fact federal courts have issued orders saying the deployments themselves are unconstitutional. The administration argues that immigration enforcement operations are being obstructed by protests and by sanctuary city policies. But courts have repeatedly found that this doesn't meet the legal threshold for invoking the Insurrection Act or other emergency powers. Another key piece of context is the Posse Comitatus Act, which was passed in 1878 after the end of Reconstruction. This law prohibits the use of federal military forces, including the Army and Air Force, for domestic law enforcement purposes except where explicitly authorized by the Constitution or by Congress. The purpose of this law was to prevent the military from being used as a domestic police force, which the framers of the Constitution feared as one of the hallmarks of tyranny. While the Posse Comitatus Act doesn't technically apply to the National Guard when it's operating under state authority, it does apply when Guard units are federalized and placed under Title X status. This is why several federal judges have cited this act in their rulings blocking Trump's deployments. Once federalized, using those Guard members for law enforcement activities violates this fundamental principle unless the specific statutory exceptions clearly apply. Finally, we need to understand the principle of federalism itself, which is absolutely central to the American constitutional system. Federalism means that governmental power is divided between the federal government and the state governments, with certain powers reserved to each level. The 10th Amendment to the Constitution explicitly states that powers not delegated to the federal government are reserved to the states or to the people. The National Guard, as a state militia that can be called into federal service only under specific circumstances, represents one of the most tangible expressions of this federalist principle. When a president federalizes state Guard units against a governor's wishes for purposes that don't clearly fall within the statutory exceptions, it's not just a policy dispute. It's a challenge to the fundamental structure of American government. With this context in mind, let's now look at exactly what has happened over the past several months and how we arrived at this constitutional crisis. The timeline of events that has led to the current crisis began in earnest during the summer of 2025. Though the seeds were planted earlier in President Trump's second term with his administration's aggressive approach to immigration enforcement and his repeated criticism of Democratic governors and mayors whom he accused of not cooperating with federal authorities. The first major deployment that sparked legal challenges occurred in California. In July 2025, President Trump issued orders federalizing units of the California National Guard and deploying them to Los Angeles ostensibly to support immigration and customs enforcement operations and to respond to protests against those operations. California Governor Gavin Newsom immediately and publicly objected to this action, stating that he had not requested federal assistance, that there was no emergency that justified federalizing his state's Guard, and that the deployment was an unconstitutional overreach of presidential authority designed to intimidate California residents and interfere with his state's policies. Newsom directed his attorney general to file an emergency lawsuit in federal court challenging the deployment. The case landed before U.S. District Judge Charles Breyer, a senior judge in the Northern District of California who was appointed by President Bill Clinton in 1997. Judge Breyer held an emergency hearing and, after reviewing the administration's legal arguments and the state's objections, issued a preliminary injunction blocking the deployment. His written opinion, which spans more than 50 pages, is worth examining in detail because it lays out many of the legal issues that have appeared in subsequent cases. Judge Breyer found that the administration's invocation of the Insurrection Act was not supported by the facts on the ground in Los Angeles. The administration argued that protests against immigration enforcement constituted a rebellion or made it impracticable to enforce federal law. But Judge Breyer noted that the protests were largely peaceful, that federal law enforcement was operating in the city without significant obstruction, and that the administration had not exhausted ordinary law enforcement options before resorting to military deployment. Most significantly, Judge Breyer wrote that accepting the administration's interpretation of presidential power would essentially allow any president to federalize National Guard units and deploy them anywhere at any time simply by declaring that federal law was being obstructed, regardless of whether that declaration was supported by evidence. He stated, and I'm paraphrasing his ruling here, that this interpretation would permit a president to create a perpetual police force comprised of state troops, fundamentally altering the balance between federal and state authority and undermining the protections against military involvement in civilian law enforcement that have existed since the founding of the Republic. The Trump administration immediately appealed Judge Breyer's ruling, but while that appeal was pending, the administration took no steps to comply with the injunction and, in fact, expanded deployments to other cities. In Portland, Oregon, a similar scenario unfolded. President Trump federalized Oregon National Guard troops and deployed them to Portland in August 2025, citing ongoing protests and what he characterized as the city's descent into lawlessness. Oregon Governor Tina Kotek filed an emergency challenge in federal court, and the case was assigned to U.S. District Judge Karen Immergut. Here's where things get particularly interesting. Judge Immergut was appointed by President Trump himself in 2019. She's not a liberal activist judge appointed by a Democratic president. She's Trump's own appointee, which makes her ruling all the more significant. Judge Immergut issued a temporary restraining order blocking the deployment and ordering that Oregon Guard members be returned to state control immediately. In her oral ruling from the bench, she stated that she was deeply troubled by the fact that the administration had kept Oregon National Guard members deployed even after she had issued initial orders, and she questioned whether the administration was acting in good faith. When the administration's lawyers argued that the president has broad authority to deploy military forces domestically, Judge Immergut responded that this interpretation was inconsistent with constitutional principles and statutory limitations on presidential power. She noted that the administration had not established a lawful basis for the federalization and that allowing it to continue would set a dangerous precedent. The administration appealed her ruling as well, but again did not immediately comply with the order. The situation in Chicago became perhaps the most legally significant because it eventually reached the Supreme Court. In September 2025, President Trump ordered the federalization of National Guard troops from Indiana and Wisconsin and their deployment to Chicago, stating that the city was experiencing violent crime and protests that made it impossible for federal law enforcement to operate effectively. Illinois Governor J.B. Pritzker, a vocal Trump critic, immediately challenged the deployment in federal court. The case was assigned to U.S. District Judge Lindsey Perry, a judge appointed by President Biden. Judge Perry held extensive hearings, taking testimony from federal officials, state officials, and independent experts. In her ruling, which is even more detailed than Judge Breyer's opinion in the California case, Judge Perry made several crucial findings. First, she found that the administration's characterization of conditions in Chicago was not supported by credible evidence. She noted that in the 48 hours before the hearing, multiple neutral parties, including grand juries, had cast significant doubt on the Department of Homeland Security's credibility and its assessment of what was actually happening on Chicago's streets. Second, she found that federal law enforcement was operating in Chicago without significant obstruction, and that the administration had not shown that ordinary law enforcement methods were inadequate. Third, and most importantly for the legal analysis, She found that the administration's interpretation of when the president can invoke emergency powers to deploy military forces domestically was so broad that it would essentially eliminate any meaningful limitation on presidential power in this area. She wrote that if accepted, the government's position would allow any president to declare an emergency and deploy troops to any city at any time based on nothing more than the president's assertion that federal law was being obstructed. Judge Perry issued a preliminary injunction blocking the Chicago deployment and ordering that troops be returned to state control. The Trump administration immediately appealed to the Seventh Circuit Court of Appeals and also filed an emergency application with the U.S. Supreme Court asking the court to stay Judge Perry's injunction while the appeal proceeded. This Supreme Court application was significant because it gave the court an opportunity to weigh in on these issues quickly rather than waiting for the normal appellate process to play out. The Supreme Court issued its ruling on the emergency application in late October 2025, and it was a significant defeat for the Trump administration. In an unsigned order, the court denied the administration's request to stay Judge Perry's injunction, meaning the block on the Chicago deployment remained in effect. The court's brief order stated that at this preliminary stage, the government has not identified a source of authority that would clearly allow military forces to execute laws in Illinois under the circumstances presented. 3 justices dissented: Justice Samuel Alito, Justice Clarence Thomas, and Justice Neil Gorsuch, all 3 appointed by Republican presidents and generally sympathetic to broad executive power. But the other 6 justices, including Chief Justice John Roberts and Justices Brett Kavanaugh and Amy Coney Barrett, who were appointed by Trump himself, did not vote to grant the stay. This is enormously significant because it suggests that even the conservative majority on the Supreme Court has serious concerns about the administration's legal position. In Washington, D.C., the situation has its own unique complications because D.C. is not a state and therefore doesn't have the same sovereignty protections. However, Congress has granted D.C.'s mayor certain authorities over the D.C. National Guard through various statutes. U.S. District Judge Jacob, who was appointed by President Biden, issued a ruling in November 2025 ordering President Trump to end the deployment of out-of-state National Guard troops to Washington, D.C. Judge Cobb found that the deployment violated both statutory provisions governing the D.C. Guard and broader constitutional principles about the use of military forces in civilian settings. She specifically warned that repeated extensions of the deployment suggested that the administration viewed the use of National Guard troops for what she called crime deterrence and public safety missions as potentially long-standing or even permanent, which she found deeply troubling. Throughout all of these legal proceedings, the Trump administration has maintained that the president has inherent constitutional authority as commander-in-chief to deploy military forces as he sees fit, and that courts should not second-guess presidential determinations about when national security or public safety requires such deployments. Administration lawyers have argued that the protests against immigration enforcement, combined with sanctuary city policies that limit local cooperation with federal immigration authorities, constitute a form of obstruction that justifies invoking emergency powers. They've also argued that the federalization of National Guard troops is different from deploying active duty military and therefore should be subject to less stringent legal limitations. The courts that have ruled against these arguments have been unconvinced, finding that accepting the administration's position would essentially eliminate judicial review of presidential decisions to deploy military forces domestically, which would be inconsistent with the constitutional system of checks and balances. In response to these unfavorable court rulings, particularly Judge Breyer's decision in the California case, Republican Congressman Randy Fine of Florida filed articles of impeachment against Judge Breyer in the House of Representatives in December 2025. Representative Fine's impeachment articles accuse Judge Breyer of issuing politically motivated rulings designed to undermine the president's authority and obstruct immigration enforcement. Fine has acknowledged publicly that the impeachment effort has little chance of success because conviction in the Senate would require a 2/3 vote, which is politically impossible with Democrats controlling the Senate. However, Fine has stated that the resolution serves an important messaging purpose. warning judges that they will face political consequences for what he characterizes as judicial activism. Constitutional scholars across the political spectrum have condemned this impeachment effort as an assault on judicial independence, noting that impeaching judges for issuing unfavorable rulings, even if those rulings are ultimately reversed on appeal, would fundamentally undermine the judiciary's ability to serve as a check on executive power. Meanwhile, Democratic officials have escalated their own rhetoric considerably. Governor Newsom has stated that Trump's actions constitute a civil war on the streets of California. Governor Pritzker has said that Trump is threatening to go to war with American cities. Representative Maxine Waters of California has warned that Trump is on the edge of creating a civil war in this country. These are not fringe politicians. These are governors and senior members of Congress using the language of armed conflict to describe what they view as an unprecedented assault on state sovereignty and democratic norms. Several Democratic governors have also stated explicitly that they believe the deployments are designed to suppress Democratic votes in the 2026 midterm elections, either through direct intimidation or by creating chaos that can be used to challenge election results. As of January 2026, the situation remains in legal and political limbo, with deployments continuing in some cities despite court orders, appeals pending in multiple circuits, and both sides preparing for what many expect to be a definitive Supreme Court ruling at some point in the coming months. The question is whether that ruling will come in time to prevent a complete breakdown in the constitutional order. Now that we understand what's happening and how we got here, we need to analyze what this all means, not just for the immediate future, but for the long-term health of American democracy and the constitutional system that has governed this country for nearly 250 years. The implications of the current crisis extend across multiple dimensions of American governance, and each one deserves careful examination. First and foremost, there's the question of federalism and state sovereignty. The United States is not a unitary nation where all power flows from a central government. It's a federal republic where power is divided between the national government and the state governments, with each level having certain areas of exclusive or primary authority. This division of power serves several important functions. It allows for policy experimentation at the state level. It provides a check against the concentration of power at any single level of government. And it reflects the reality that a country as large and diverse as the United States cannot be effectively governed by a one-size-fits-all approach from Washington. The National Guard system embodies this federalist principle. When Guard members are under state control, they serve the people of their state under the direction of their elected governor. This means that governors can respond to emergencies and maintain order in their states without having to request permission from the federal government. The ability of the president to federalize the Guard exists for genuine national emergencies when federal authority needs to be enforced or when a state is unable or unwilling to maintain order on its own. But what happens when federalization becomes a routine tool for a president who disagrees with state policies or wants to assert dominance over opposition governors? What happens when the extraordinary becomes ordinary? If President Trump succeeds in establishing that he can federalize Guard units and deploy them to states essentially at will, the practical autonomy of states is dramatically reduced. Future presidents of any party would have this precedent to point to. A Democratic president could federalize Texas Guard units and deploy them to Austin or Houston. A Republican president could federalize New York Guard units and deploy them to New York City. The federalist balance that has existed for over 2 centuries would be fundamentally altered, with states becoming more like administrative subdivisions of the federal government rather than sovereign entities with their own areas of authority. Second, there's the question of military involvement in civilian life and domestic law enforcement. One of the fundamental principles of liberal democracy, meaning democracy based on individual rights and rule of law, is that military forces should not be used as a domestic police force. This principle is rooted in the understanding that military forces are trained to defeat enemies through overwhelming force, not to protect constitutional rights and maintain civic order through community policing. When soldiers patrol your streets, even National Guard members who are citizen soldiers with ties to the community, the relationship between government and citizen changes fundamentally. The presence of military forces creates a climate of intimidation that can chill the exercise of constitutional rights like freedom of speech, freedom of assembly, and freedom to petition the government for redress of grievances. If you know that troops are patrolling your city and that those troops are there because the president ordered them, they're over your governor's objections, how free do you feel to participate in protests or political organizing? The founders understood this danger, which is why they were deeply suspicious of standing armies, and why they included protections in the Constitution against military involvement in civilian affairs. The Posse Comitatus Act, passed after Reconstruction, was designed to prevent the military from being used as the federal government's domestic enforcement arm. When that principle is eroded, when troops on American streets becomes normalized, the nature of American democracy itself changes. We move closer to the kind of government where military force is a routine part of political life rather than an emergency measure reserved for the most extreme circumstances. Third, there are the implications for judicial independence and the separation of powers. The federal judiciary exists to serve as a check on the other branches of government, to interpret the Constitution and laws, and to protect constitutional rights even when doing so is unpopular. Federal judges have life tenure, meaning they can only be removed through impeachment for high crimes and misdemeanors, specifically so that they can make decisions based on the law rather than political pressure. When a member of Congress files articles of impeachment against a federal judge because a judge issued a ruling that was unfavorable to the president's policy preferences, it's an attack on this independence. Now, to be clear, the Constitution does allow for the impeachment of federal judges, and there have been cases throughout history where judges were impeached for genuine misconduct, corruption, or violations of their oath of office. But impeaching a judge for making a legal ruling that you disagree with, even if you believe that ruling is wrong, is fundamentally different. If judges face political retaliation every time they rule against the president or Congress, they are no longer truly independent. They become actors in a political system rather than interpreters of law. This is particularly dangerous when it comes to cases involving the limits of executive power. The only effective check on a president who is determined to exceed constitutional boundaries is the judiciary's willingness to say no and enforce those boundaries. If judges become reluctant to do so because they fear impeachment or other political consequences, the check fails, and we're left with an executive branch that is effectively unconstrained by law. The situation is even more concerning because some of the judges who have ruled against the Trump administration's deployments are Trump's own appointees. Judge Immergut in Oregon and Justices Kavanaugh and Barrett on the Supreme Court were all appointed by Trump, yet they've been willing to rule against him when they believe the law requires it. This is actually the system working as intended. Judges are supposed to interpret the law rather than simply supporting the president who appointed them. But if Trump supporters in Congress see even Trump appointees as targets for impeachment when they rule the wrong way, it sends a message that absolute loyalty to the president, not fidelity to the Constitution, is what's expected. Fourth, there's the question of political rhetoric and the normalization of extreme language. When governors and members of Congress start using phrases like civil war to describe political conflicts, even if they believe they're accurately characterizing the severity of the situation, it has real effects on how people understand what's happening and how they respond. Political rhetoric doesn't just describe reality. It shapes reality by influencing how people interpret events and what actions they consider appropriate. If political leaders are telling their supporters that we're in or approaching a civil war, some people will start to think and act as if we're in a civil war, which means viewing political opponents not as fellow citizens with different views, but as enemies who must be defeated by any means necessary. This is particularly dangerous in a country with more guns than people and a history of political violence. The language of civil war has been used by figures on both sides of the political divide in recent years, and while it's understandable given the severity of the current crisis, it's also deeply worrying. Civil wars don't usually start because everyone suddenly decides to start fighting. They typically begin with a series of escalating conflicts where each side feels justified in taking actions that would have been unthinkable a few years earlier. The rhetoric normalizes the escalation and makes each step seem reasonable in response to what the other side did. Fifth, there's the electoral dimension of this crisis. Multiple Democratic governors and officials have explicitly stated their belief that the National Guard deployments are designed to suppress Democratic votes in the 2026 midterm elections. Whether or not this is Trump's actual intent, and different people will have different views on that, the perception itself is damaging. Trust in elections is fundamental to democratic governance. When significant portions of the population believe that elections are being manipulated through military intimidation or other means, it undermines the legitimacy of whoever wins those elections. We saw this after the 2020 presidential election, when Trump's false claims about election fraud led to the January 6th Capitol attack and ongoing doubts about election integrity among a large portion of the Republican base. Now we're seeing similar concerns being raised from the Democratic side about the 2026 midterms. The presence of federal troops in major Democratic cities during an election year, regardless of the stated justification for those deployments, creates the appearance of impropriety even if no actual interference with voting occurs. And if Democrats lose seats in the House or Senate that they were expected to win, particularly in states or districts where troops were deployed, many Democrats will attribute those losses to intimidation or interference, just as many Republicans attributed the 2020 results to fraud. This is a recipe for a complete collapse in shared understanding of electoral legitimacy, which is one of the foundations of democratic governance. Sixth, there's the question of what precedents are being set that will affect future administrations. Every action taken by a president, especially when that action pushes the boundaries of existing norms or legal interpretations, becomes a precedent that future presidents can point to. If Trump succeeds in establishing that a president can federalize National Guard units and deploy them domestically based on broad claims about obstruction of federal law or public safety concerns, that power will be available to every future president. Imagine a future Democratic president deciding to federalize Texas Guard units and deploy them to the border not to support immigration enforcement, but to monitor and document potential human rights violations in immigration detention facilities. Imagine that same president federalizing Florida Guard units and deploying them to ensure access to abortion services at clinics where protesters are present. If you're a conservative who supports Trump's current actions, would you be comfortable with a progressive president having and using those same powers? Conversely, if you're a progressive who is alarmed by Trump's actions, you should be equally alarmed by the precedent, even if you might be tempted to think that a Democratic president would use such powers for better purposes. The point is that powers, once established, don't belong to any individual president or any particular party. They belong to the office of the presidency and will be used by whoever holds that office. This is why constitutional constraints on power are so important. They protect us not just from the current president, but from all future presidents who might abuse unchecked authority. Seventh, and finally, there's the question of what comes next, and whether the current trajectory can be reversed before permanent damage is done to the constitutional order. The fact that multiple federal courts, including the Supreme Court, have been willing to rule against the Trump administration's deployments is encouraging because it suggests that the judicial check on executive power is still functioning to some degree. However, the administration's pattern of continuing deployments despite court orders, appealing every unfavorable ruling, and having political allies threaten judges with impeachment suggests a strategy of simply overwhelming the judicial system through persistence and intimidation. There's also the question of what happens if the administration simply refuses to comply with a final Supreme Court ruling. We've never had a situation in modern American history where a president openly defied a clear Supreme Court order, but we're also in unprecedented territory in many other ways. The constitutional system ultimately depends on a shared commitment to following its rules, even when doing so is politically inconvenient. If that commitment breaks down, if one branch of government simply refuses to recognize the authority of another branch, the Constitution becomes just a piece of paper rather than a functioning framework for governance. These are not abstract concerns or hypothetical scenarios. These are real possibilities given the trajectory of events over the past several months. The next few months will likely be decisive in determining whether the American constitutional system can withstand this stress test, or whether we're witnessing a fundamental transformation in how American government operates. So where does all of this leave us? We're at a genuine crossroads for American democracy, and the direction we take from here will have consequences that extend far beyond President Trump's term in office or the 2026 midterm elections. What we're witnessing is a stress test of American constitutional democracy, and the outcome of that test is not predetermined. History shows us that democracies can be surprisingly resilient, capable of surviving severe crises and emerging stronger. But history also shows us that democracies can fail, and they usually fail not through a single dramatic coup, but through a series of norm violations and power grabs that accumulate over time until the system is fundamentally transformed. Each action taken in the current crisis, the federalization of guard units, the deployment of troops to opposition cities, the judicial rulings against those deployments, the threats of impeachment against judges, the Civil War rhetoric from political leaders. Each of these developments might seem like isolated incidents that can be understood and managed on their own terms. But when you step back and look at the pattern, when you see how each action feeds into and escalates the next, it becomes clear that we're in a different kind of situation than the normal ups and downs of American politics. The fundamental question is whether the American system of checks and balances, which has existed for nearly 250 years and has survived civil war, world wars, economic depressions, and countless political crises, can contain a determined executive who views constitutional constraints not as legitimate limits on power, but as obstacles to be overcome. The answer to that question depends not just on institutions and laws, but on the choices made by individual people. Judges who must decide whether to enforce constitutional limits, even in the face of political pressure. Members of Congress who must decide whether to prioritize partisan loyalty or constitutional duty. State officials who must decide how to respond to federal overreach. And ultimately ordinary citizens who must decide what kind of country they want to live in and what they're willing to do to preserve or transform it. There's also an important point about perspective here. If you're someone who supports President Trump and his policies, you might view the current situation very differently than I've presented it. You might see a president who is trying to enforce federal law and maintain public safety against obstruction from Democratic governors and cities, and who is facing politically motivated lawsuits from opposition judges. That's a legitimate perspective, and I want to acknowledge it. But I would ask you to consider this. Even if you believe Trump's actions are justified right now, do you want every future president to have the same powers you're defending? Do you trust a future Democratic president with the ability to federalize guard units and deploy them to Republican states based on broad claims about obstruction of federal law? If the answer is no, then you should be concerned about the precedents being set right now, regardless of your views on Trump's specific policies.